All right, well, we have the all clear here to begin. We'll call the case of Marks v. Sonny's Rooftop Bar to order. My name is Judge Jeff Blank, and scoring judges, please look to the buttons on the lower left of your screen and turn off your audio and video, which you've done. These should remain off until the trial ends. And you should also have your video set to hide all non-video participants. So this means the only people on the screen right now should be the advocates and myself. And at this time, can we please have our attorneys state their appearances for the record?
Yes, Your Honor. Good morning. My name is Victoria Smith, and today I am joined by my second chair, Mr. Nathan Mahari.
Thank you. Good morning. And how about appearances for the defense?
Good morning, Your Honor. My name is Christina Davenport, and I'm joined today by my second chair, Sarah Igel-Storder. And together we represent the defendant, Sonny's Rooftop Bar, represented in court today by their owner, Ms. Sonny Mehta.
Good morning, Your Honor.
Good morning. Thank you very much. Before we begin with opening statements, I know oftentimes the attorneys have some preliminary matters, oftentimes referred to as housekeeping matters. Ms. Smith, do you have any such matters to bring to the court's attention?
Yes, Your Honor. First, we would ask, in accordance with Evidence Rule 603, to consider all witnesses constructively sworn in.
Yes, they will be constructively sworn in.
Next, we would like to note under Evidentiary Rule 11 that Exhibits 1, 22, and 23 are all pre-admitted.
Yes, per the pretrial order number 11. So those are all pre-admitted.
And with that, Your Honor, the plaintiff is ready to proceed.
Excellent. And Ms. Davenport, any preliminary matters for the defense?
Yes, Your Honor. We would also like to mention that there are a couple pretrial orders we'd like to bring to your attention. Pursuant to pretrial order 2, Judge Pasquarello has granted a motion to bifurcate this case, and today's trial will deal only with liability and not damages.
So noted. Anything further?
No, Your Honor. The defense is also ready to proceed.
All right. Before we begin with opening statements, everyone should make sure they are in speaker view. That button is in the upper right of your screen. And attorneys, please remember to mute your audio when the other attorney is speaking. And with that, Ms. Smith, whenever you are ready for your opening statement, you may proceed.
Yes, Your Honor. Little to no thought. Sonny's Rooftop Bar's lack of thought is what led to the tragic death of Jessica Marks. It's 9 p.m. on March 24th, 2019. Jessica Marks and her best friend Morgan Levin walk into Sonny's Rooftop Bar looking to have a fun time on their spring break vacation. The only problem? The two are only 19 years old. But still, they are served drink after drink, and their server, Sonny Mehta, puts little to no thought into it. 2.5 hours and nearly 8 drinks later, Miss Marks starts to become drunk. She starts displaying signs of being intoxicated. Miss Marks starts slurring her speech. Her eyes start getting a little watery. She starts not really making sense. But no one says anything. No one does anything. Miss Marks is still served. So at 11:45 p.m., when Miss Marks stumbles out of the bar with her car keys in hand, no one says anything. Instead, Miss Marks gets into her car, gets behind the wheel, and starts to drive. But because of how intoxicated Miss Marks is, she doesn't make it more than 1,000 feet before she swerves off the road, crashes, and dies. The plaintiff is suing Sonny's Rooftop Bar for the wrongful death of Jessica Marks because the evidence will show Sonny's Rooftop Bar failed to pay enough attention. The evidence will show 3 major ways that Sonny's Rooftop Bar put little to no thought about the safety of Miss Marks on March 24th, 2019. First, the evidence will show that Sonny's rooftop bar gave how intoxicated Miss Marks was little to no thought. Today, you will hear from Miss Marks' best friend, Morgan Levin, and you will hear that Miss Marks became more and more intoxicated as the night went on. Second, the evidence will show that Sonny's rooftop bar gave little to no thought about how much they were serving Miss Marks. Today, you will see a receipt from the night of the 24th, a receipt highlighting the numerous rounds of drinks that were ordered and served to Miss Marks. And you will also see a video of how she was acting that night, a video where she was displaying signs of intoxication, but yet had full beverages in front of her as she was never cut off. And finally, the evidence will show that Sonny's rooftop bar put little to no thought about Miss Marks getting into a car after drinking. The evidence will show today that even though Miss Marks stumbled in front of the bartenders, no one said a word. They let her get in her car, drive away, and die. Now, the plaintiff has the burden of proof today, which is preponderance of the evidence. That means at the end of today's case, if you believe it is more likely than not that Sonny's rooftop bar is at fault, then you must find them liable. The evidence will show that the only reasonable answer is that Sonny's rooftop bar failed to pay enough attention. Their lack of thought led to her tragic death. At the end of today's trial, I will ask you to return a verdict of liable. Thank you.
All right, thank you very much, Ms. Smith. Ms. Davenport, whenever you're ready for the defense opening statement, you may proceed.
Yes, Your Honor. May it please the court, opposing counsel, members of the jury. You can't control what you can't see. Now, Ms. Smith just came up here and told you the story of Jessica Marks. Ms. Smith told you Jessica visited her friend in LA for a fun spring break. Then one night, she got carried away and decided to drink at Sonny's rooftop bar and then drive home. Members of the jury, no one is going to stand here and tell you that the loss of Jessica Marks isn't a tragedy. We all sympathize with the pain that the Marks family is going through, because we know that when a loved one passes, it's only natural to find someone to blame. It's only natural to assume that the bar owner, Sonny Mehta, is responsible for Jessica's death. But what you will see is not that Sonny Mehta didn't have little to no thought. Instead, what actually happened was that he couldn't control what he couldn't see. Now, Ms. Smith and I actually agree on the law. We agree that Jessica Marks was a minor. We agree that Jessica Marks was intoxicated the night of March 24th. And we agree that Jessica Marks' intoxication led to her death. But the plaintiff and I disagree in one key area: that Sonny Mehta could see how intoxicated Jessica Marks was. Now, the plaintiff has sued Sonny's rooftop bar for wrongful death. In the state of California, there's a law called the Dram Shop Act. This law holds bars responsible for injuries caused by over-serving. But the plaintiff holds the burden of proof. This means that they have to prove 4 things by a preponderance of the evidence, or in other words, that it's more likely true than not true. 1, Jessica Marks was a minor. 2, that Sonny's rooftop bar served Jessica alcohol. 3, that Mr. Mehta knew Jessica Marks was obviously intoxicated when they served her alcohol. And 4, that her intoxication is what led to her death. But the plaintiff will not be able to prove that to you today. They will not be able to prove that Mr. Mehta knew Jessica was obviously intoxicated. And that's because you can't control what you can't see. Members of the jury, when you hear the evidence today, I want you to focus on what Mr. Mehta could see that night. I want you to ask yourselves a question. How could Mr. Mehta know how drunk Jessica was based on what he could see? Today in court, you will hear from Ms. Mehta himself. He will tell you about the protocols the bar follows and the safety courses his employees take to make sure that they don't overserve their customers. He'll tell you about the training courses they go through to know when someone is intoxicated. And Mr. Mehta will come up here and tell you that the few times that she spoke to Jessica throughout the night, she seemed perfectly fine. He never saw her slurring her words. He never saw her stumbling around. He never saw her lose her balance. Mr. Mehta will come up here and tell you he didn't cut Jessica off because he couldn't control what he couldn't see. At the end of hearing all the evidence in court today, you'll find Mr. Mehta couldn't control Jessica because he never saw her act intoxicated. Members of the jury, you can't control what you can't see. Find the defendant not liable. Thank you.
All right, thank you, Ms. Davenport. Before the plaintiff calls its first witness, I'll ask everyone to switch to gallery view. That button's in the upper right of your screen. This will allow you to see the attorneys and the witnesses at the same time. And with that, Ms. Smith, you may call your first witness.
Yes, Your Honor. The plaintiff calls Morgan Levin to the stand. May I proceed?
Yes, you may.
Please introduce yourself to the jury.
Hi, my name is Morgan Levin. I'm sorry, I haven't really done this before.
Ms. Levin, can you tell the jury what you do for a living?
I'm a student at UCLA.
How are you connected to today's case?
Jessica Marks was my best friend, and I was with her on the night that she passed away.
Ms. Levin, would you recognize a picture of Ms. Marks if it was shown to you in court today?
Of course.
Now showing on the screen outside the presence of the jury, Exhibit 2. Do you recognize this picture?
Yeah, that was Jessica. That was our grad night in high school.
Is it true and accurate to the best of your knowledge?
It is.
Move to admit Exhibit 2 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 2 will be admitted.
Were you with Ms. Marks on March 24, 2019?
I was.
Where were you and Ms. Marks on that day?
We were in LA. She had come down from Pennsylvania over spring break.
And when did you and Ms. Marks meet up on March 24th?
Jessica came over to my dorm at 6 p.m. and then we went to her Airbnb that she had rented between 7 and 8.
What did you do at Ms. Marks's Airbnb?
I mean, we're basically just talking, listening to music. We had a few glasses of wine.
How old were you and Ms. Marks at the time?
19. We have the same birthday.
Did you and Ms. Marks stay at her Airbnb on March 24th?
No, we went to Sonny's rooftop bar that night.
And who drove you to Sonny's?
Jessica did. She had a rental car.
And, what did you observe Ms. Marks's driving to be like when you were heading over to Sonny's?
I mean, it seemed to be pretty normal and safe. She was maybe driving a bit slower than she normally would.
And do you remember what time the two of you arrived at the bar?
9 p.m.
I want to discuss what you did once you arrived at Sonny's rooftop bar. What did the two of you do when you first got to Sonny's?
We went up to the rooftop, sat at a table, and then we started ordering drinks.
And do you know who took your drink orders that night?
I do. It was the bar's owner, Sonny Mehta.
Do you remember getting a receipt on the night of the 24th?
Yes, at the end of the night.
And would you recognize a picture of this receipt if it was shown to you in court today?
I would.
Now displaying outside the presence of the jury, Exhibit 17. Do you recognize this?
Yes, that's our receipt from that evening.
Is it a true and accurate copy of that receipt?
From what I can see, yes, it is.
And from what you can see, has it been changed or altered in any way?
No, that's the receipt we were given that night.
Move to admit Exhibit 17 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 17 is admitted.
Ms. Levin, could you please explain to the jury what we're looking at here on the screen?
This is the receipt that Jessica and I were given. It has the drinks and, well, I guess the food too that we had that evening at Sonny's.
Did you drink everything on this receipt?
No, this receipt has both me and Jessica's drinks on it.
Could you please tell the jury what on this receipt you drank?
Yeah, I had one glass of wine from that bottle of Decoy Red. I had a beer, and I'm pretty sure I had one of the green tea shots.
And what did Jessica drink?
I mean, everything else that you see there. I know she had the rest of the bottle of wine. She had the White Claws because I don't drink White Claw. She had a beer and then the other green tea shot.
And is everything that Miss March drank on this drank on March 24th on this receipt?
No, I remember her also having a Captain Morgan rum and Coke. She said that she got it for free from flirting with the bartender Frankfurt.
How would you describe Miss Marx's behavior throughout the course of the night on the 24th?
I mean, she wasn't acting like herself. I could tell as the night went on, she seemed to be more drunk.
And, what do you mean by she started to seem more drunk?
Well, she got louder. What she was saying didn't always make sense. Like her words were slurring a little bit. Her eyes seemed pretty red, a little watery, bloodshot. And then toward the end of the night, she was stumbling as well.
Do you know if anyone else saw Miss Marx stumble?
Yes, there was one point where we were coming down the stairs of the bathroom. Jessica stumbled, and the owner, Sonny, Mehta, caught her and said, "Whoa, Frankfurt, we may need to cut this one off."
Did Mr. Mehta say anything else relating to Miss Marx's behavior that night?
Yeah, at one point toward the end of the night when we were ordering those green tea shots, Sonny pointed at Jessica and then looked at me where she said, "I hope this one's not driving."
And at that point, did Miss Mehta cut Miss Marx off?
No, she was never cut off.
Now, I want to go more into detail about Miss Marx's behavior before the two of you left the bar. Prior to today's trial, were you shown Exhibit 10?
Yes, I was.
And would you recognize that video if it was shown to you in court today?
I would. I was the one who took the video.
Now displaying on the screen outside the presence of the jury, Exhibit 10. From this screenshot, do you recognize this video?
I do. Yes, that's the video of Jessica I took.
Is it true and accurate?
From the frame I can see right now, it is, yes.
The plaintiff moves to admit Exhibit 10 into evidence.
Any objection?
Yes, Your Honor. An objection to hearsay. May I be heard?
Yes.
Your Honor, under 801, we are specifically objecting to the nonverbal conduct in this video because the actions Jessica takes, like slamming down her drink or having her glasses on backwards, are nonverbal conduct that are being used to prove the truth of the matter asserted that she was obviously intoxicated.
Your Honor, may I respond?
Yes.
Under Evidence Rule 804A, this is declarant unavailable due to death, meaning that these statements are not hearsay and therefore should be admissible in today's trial.
Any response as to the response about the declarant being unavailable?
Yes, Your Honor. These actions are still inadmissible because they are proving that she was obviously intoxicated, and they are nonverbal statements. And even though she isn't present in court today, we ask for a specific limiting instruction that the jury doesn't take in the actions that she conducts in the video.
Your Honor, may I respond?
Yes.
Your Honor, then this would go to the weight and not admissibility, as the trier of fact can determine whether or not they want to put weight on Ms. Marks's actions in this video.
Yeah, the court tends to agree. The court will overrule the hearsay objection.
Yes, Your Honor.
Just to confirm, is Exhibit 10 admitted, Your Honor?
Yes, Exhibit 10 is now admitted.
No, Ms. Levin, do you remember what time this video was taken?
I took it around 11 p.m.
And what time did the two of you end up leaving Sonny's?
11:45.
How did you plan on getting home?
Well, I called an Uber because I didn't really feel safe driving with Jessica, and I mean, we had both been drinking.
Did Ms. Marks get in the Uber with you?
No, she said that she was fine and that she could drive herself home.
Did anyone working at the bar try to stop Ms. Marks from driving?
No, no one did anything.
Thank you. No further questions.
All right, thank you. Cross-examination.
Yes, Your Honor. Now, Ms. Levin, I understand this may be difficult for you, so if at any minute you just need a moment, please let me know.
Thank you.
I'd like to begin by talking about that night. Now, your memory of that night is not perfect, right?
No, it's not.
You can't tell us everything that happened.
No, I can't.
And that's because March 24th, 2019 was over 2 years ago.
It was.
And not only that, but you were drinking that night, right?
Yes, I was.
Ma'am, you didn't just have one drink, did you?
No, ma'am, I had 3 drinks that evening.
Now, you mentioned on direct, you first had a glass of wine before you left Jessica's Airbnb, right?
Yes, I did.
And once you got to Sonny's rooftop bar, you had a beer?
I did have a beer, yeah.
And then you had another glass of wine.
I did. I just had 1 glass of wine out of that bottle.
And then you had a green tea shot.
Yeah, toward the end of the night.
Ma'am, that's 4 drinks that you had that night, right?
That is 4 drinks. The 3 I was talking about was the 3 that I had at Sonny's.
Now, I want to talk about how those 4 drinks might have been affecting your memory at the end of that night. When you left the bar, you paid for your drinks that night, right?
Yes, I paid for both Jessica and I's drinks.
You got this receipt.
Yes, that was our receipt.
You got this receipt at 11:41 p.m., right?
That's the timestamp on there, yes.
That was right before you left the bar, right?
It was.
And if you look to the bottom of this receipt, you had a $119 bill, right?
And 58 cents, yes.
Mm-hmm. And you left a $20 tip?
I did.
And ma'am, you added 119 plus 20, and you got 149, right?
That is what it says on there.
And you know, don't you, that 119 plus 20 is 139?
I do know that now. Sorry, studying to be a biologist, not a, mathematician.
Mm-hmm. Now, I want to focus on what Miss Mehta could see that night. That night, you saw Miss Mehta interact with Jessica about 8 to 10 times, right?
Yeah, that's how many times she was at our table.
And ma'am, none of those times did they have an in-depth conversation, did they?
No, I'd say it was maybe 30 seconds to a minute.
Exactly. They didn't have an in-depth conversation because they only spoke for about 30 seconds each time.
That's what I said.
And they only talked long enough to order drinks.
Yeah, I mean, they joked around a few times, but...
And only long enough for Mr. Mehta to then come back and drop them off.
Yes, she was delivering our drinks that night.
And out of those 8 to 10 times that Mr. Mehta spoke to Jessica, you can't think of a single time Jessica was slurring her words, can you?
No, I can't think of a specific time in front of the employees, but she was acting like that all night. I know what I saw.
And out of those 8 to 10 times that Miss Mehta spoke to Jessica, you can't think of a specific time Jessica had bloodshot eyes, right?
No, she was like that all night, but I didn't write down a specific time.
In fact, that whole night, you can't point to a specific single symptom that Jessica had that made her look intoxicated in front of Miss Mehta.
I mean, I saw her fall down the stairs in front of Miss Mehta, but if you're referring to those other symptoms, then no, I didn't write down a specific time.
Thank you, Your Honor. No further questions.
All right, any redirect examination?
Yes, Your Honor.
You may proceed.
Ms. Levin, after that video was taken that we discussed earlier, was Ms. Marks ever cut off?
Objection, Your Honor. May I be heard?
What's the specific objection?
This is out of the scope of my cross. I
Okay,
never
yeah.
spoke about the video.
Okay, response to that, Ms. Smith?
Yes, Your Honor. Opposing counsel opened the door for this inquiry when on cross-examination, she was referring to the different signs of Ms. Marks, talking about whether or not she had slurred her speech, talking about whether or not she was making sense. All of these lead to Exhibit 10, that video, and therefore is within the scope of her cross-examination.
Your Honor, may I respond?
Yes.
Me talking about these specific symptoms does not in no way lead to Exhibit 10. Me simply talking about them in general throughout the whole night is no direct reference to the exhibit in the video itself. Therefore, this would still be out of the scope of my cross since opposing counsel is directly asking about after the video was taken.
So as the question is phrased, the court will sustain the objection. However, there may be able to ask certain questions about the video if it directly pertains to the scope of testimony that Ms. Smith referenced, but I think as phrased, it's asking and assuming that the witness saw the video. So based on those grounds, the objection is sustained as outside the scope of cross.
Yes, Your Honor.
Throughout the course of the night, did you ever see Miss Mehta cut off Miss Marks?
No, Miss Marks was never cut off that night.
Thank you. No further questions.
Any recross?
No recross, Your Honor.
All right. We will excuse the witness then. And with that, Ms. Davenport, you may call your first witness. I assume the plaintiff rests as there's only one witness on the witness list?
Yes, Your Honor, the plaintiff rests.
All right. Defense may call its first witness.
Yes, Your Honor. The defense calls Sonny Mehta to the stand. Good morning. Could you please introduce yourself to the jury?
Good morning, of course. My name is Sonny Mehta.
Could you tell us a bit about yourself?
Yeah, of course. I used to be a bar owner. Now I'm just a businesswoman. Before that, I was in maintenance. I was an assistant property manager, that sort of thing.
Now, I want to start by talking a bit about your bar. Do you like owning a bar?
Of course. I mean, it's one of my favorite things, just talking, interacting with customers is just fantastic.
And do your employees have to go through any certification courses to work at your bar?
Absolutely. Any business that sells alcohol in California has to complete a state-approved responsible beverage service course and pass an exam. All my employees take the exam every 3 years and are current in their certification.
And what do these courses cover?
Just understanding how alcohol can impact a person, how you can't serve anyone under 21, and recognizing when someone is obviously intoxicated.
Now, I want to talk a little bit about how you can recognize when someone is obviously intoxicated. What does it mean to be obviously intoxicated?
Well, it's when someone is showing obvious signs that they've been drinking, to the point where we should no longer be serving them. There's a difference between being tipsy or buzzed and obviously drunk.
And what are the signs of obvious intoxication?
Well, it could be red, watery eyes, a vacant gaze, flushed cheeks, loss of balance, lack of hand-eye coordination, slurred speech, passing out, that sort of thing.
And does the amount of alcohol someone consumes tell you that they're obviously intoxicated?
I mean, not at all. Everyone handles their alcohol differently based on size, tolerance, genetics.
Now, I want to address some of the allegations against you. Were you in court when Miss Smith showed us the video of Jessica at your bar?
Yeah, I was.
And did you ever see Jessica acting like she did in that video?
I didn't. I mean, knowing what happened to her, I wish I had, but I just didn't see anything like that night.
And were you there when that video was filmed?
I wasn't.
Now, I want to talk about when Jessica Marks came to your bar. When Jessica first arrived at 9, did she seem intoxicated?
To me, no.
And I want to go back to those signs of intoxication that we discussed a minute ago. Let's go through those one by one. Did Jessica have red, watery eyes?
From what I can remember, she didn't.
Were Jessica's cheeks flushed?
No.
Did she have a heavy stench of alcohol?
No.
Did she ever lose her balance?
Not that I can remember.
Did she have trouble standing?
No.
Was her speech ever slurred?
No, I talked to her throughout the night. I never heard any sort of slurred speech.
Or was she talking loudly?
No.
Or was she not making sense?
From what I saw, no.
And was she ever passed out?
Passed out? Absolutely not.
And throughout the night, did Jessica ever seem obviously intoxicated?
No. I mean, she never looked or acted drunk, and if she did, it wasn't in front of me.
So, did you ever feel the need to cut Jessica off from drinking?
Absolutely not. No.
Thank you, Your Honor. No further questions.
All right, thank you. Cross-examination?
Yes, Your Honor. May I proceed?
Yes, you may.
Now, Ms. Mehta, on direct examination, you referred to the signs of obvious intoxication a lot. I want to discuss some of those. Well, one of these signs is not making sense.
That can be one of the signs, yes.
Another could be slurring your speech.
Again, it can be.
Loss of balance is another one.
Sure, yes.
And also talking loudly.
Yeah.
And on direct examination, you were asked if you were familiar with Exhibit 10. You are familiar with that exhibit?
Well, now that I've seen it in court, yes. I hadn't seen it prior to today.
Now displaying on the screen previously admitted Exhibit 10. One moment, Your Honor. I believe my second chair is having a few technical difficulties.
Sure.
Could you play that video, please?
Hi, everyone. Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Now, this video was taken at your bar, right?
Looks like it, yes.
And this is how Miss Marks was acting at your bar at 11 p.m.?
I don't know.
But in this video, this is how she's acting, right?
Yes.
And this video was taken around 11 p.m.?
I believe so. This is not how I saw her, though.
And as seen by this video, at 11 p.m., Miss Marks was still drinking.
Looks like it.
But you weren't concerned about Miss Marks?
I mean, no, I didn't see the signs that showed she was obviously intoxicated.
You didn't say anything about Miss Marks driving.
No,
You believe that Miss Marks didn't display any signs of intoxication.
yeah,
Now, you also saw Miss Levin drink on March 24th.
a bit. Yes, I believe so.
And you saw that Miss Levin was ordering drinks at the same time as Miss Marks.
Yeah, they were drinking together.
And it was your impression they were drinking around the same amount.
I believe so. You know, I didn't spend much time at their table. I couldn't know for sure.
But you went to their table around 8 to 10 times.
Yeah,
And you saw Miss Levin start to appear buzzed as the night went on.
yes, I mean, she had been drinking.
Miss Levin started to display signs of intoxication.
Some signs.
But you never cut Miss Levin off.
No, I didn't feel I had reached that point.
Now, I want to move on to what happened after Miss Marks left your bar. You're aware that Miss Marks crashed her car after leaving Sonny's?
No, I am. Yes.
And Miss Marks died in that car crash.
Yes, it's such a tragedy.
Now, Mr. Mahari, could you please display on the screen pre-admitted Exhibit 22? Now, this is Jessica Marks's autopsy report. And you can see from this exhibit that Miss Marks's blood alcohol content that night was 0.16, right?
I can. I mean, it doesn't tell you anything about how she was acting, but that is what it says there.
And you know as a bartender that the legal limit for someone of age is 0.08.
Yes, I do know that.
And you know for a minor, it's only 0.01.
I do know that, yes.
And you now know that Miss Marks was only 19 years old.
Yes, I do that. I do know that.
And you remember serving Miss Marks multiple rounds of drinks.
I do remember that.
But at no point on March 24th, 2019, did you cut Miss Marks off.
No, as I said, I didn't feel it was necessary. I just didn't see any signs.
Thank you. No further questions.
Thank you. Any redirect?
Yes, Your Honor, briefly.
Sure, whenever you're ready.
Well, Miss Mehta, did Miss Marks ever display any symptoms of intoxication?
From what I saw that night, no.
So did you have any reason to be concerned of Miss Marks?
No, no reason to be concerned.
And is there a specific formula for knowing how intoxicated someone is?
There is no specific formula. Everyone handles their alcohol differently.
Thank you, Your Honor. No further questions.
All right, thank you. Any recross?
No recross, Your Honor.
All right, anything further from the defense?
No, Your Honor. At this moment, the defense rests.
All right, we can just take a moment for our scorers to finish the scoring and on the witnesses now that the witness presentations are complete, and then we'll start closing arguments in about 30 seconds. And with closing arguments, everyone should switch back to speaker view. All right. Ms. Smith, whenever you are ready, you may proceed with the plaintiff's closing argument.
Yes, Your Honor. Little to no thought. This is Jessica Marks. Today, you received a brief introduction to who she was. An active college student, a fun friend. But that's not how the employees at Sonny's rooftop bar viewed Miss Marks. Instead, they viewed her like this: another customer, another way to pay their bills, simply another receipt. That's why on March 24th, 2019, Sonny's Rooftop Bar gave Jessica Marks little to no thought. We, the plaintiff, have the burden of proof today. In today's case, the bar is preponderance of the evidence, meaning that if it's even a little bit more likely than not that Sonny's Rooftop Bar is to blame for Miss Marks's untimely death, then the law requires that you find them liable. Based on jury instruction number 8, any person or business who is licensed to sell alcohol is liable for death caused by selling that alcohol to any obviously intoxicated minor. Based on jury instructions, there are several factors that prove the defendant is at fault. First, the defendant saw that Miss Marks was intoxicated on March 24th, 2019. Jury instruction 12 mandates looking at how a reasonable person would view Miss Marks's level of intoxication. If a reasonable person would have believed that Miss Marks was drunk, then it is reasonable to believe she was obviously intoxicated. Second, the defendant continued to serve Miss Marks even after seeing she was intoxicated. And finally, that Sonny's Rooftop Bar was a substantial factor in Miss Marks's death. Let's discuss how all of these elements were met when Sonny's Rooftop Bar chose to act carelessly on March 24th, 2019. First, the employees at Sonny's Rooftop Bar gave little to no thought about how intoxicated Jessica Marks was on March 24th. Miss Levin told you today how she was in the car with Jessica Marks before they went to the bar on March 24th, and that she saw how she was driving. Miss Levin explained that Miss Marks's driving was normal, maybe even being a little bit more cautious than usual. It was after Miss Mehta served Miss Marks multiple rounds of drinks that she became unsafely intoxicated. Miss Marks started displaying signs of obvious intoxication: slurred speech, lack of coordination, a loud voice. Miss Levin told you today that Miss Marks even fell right in front of Miss Mehta on the way out the door, but Miss Mehta did nothing. That leads to the second way that Sonny's Rooftop Bar employees failed to care, when they didn't think twice about how much they were serving Jessica Marks. Today you were shown Exhibit 17, the receipt from March 24th. This exhibit reveals that 8 alcoholic beverages were purchased on the night that Miss Marks died. You heard today how Miss Mehta continued to come to Miss Marks and Miss Levin's table throughout the night, serving them drink after drink. You also saw a video of Miss Marks from March 24th. This video was taken at 11 p.m., merely 40 minutes before her tragic accident. The video shows Miss Marks displaying signs of intoxication, but yet still has full glasses of alcohol in front of her, since she was never cut off. And finally, Sonny's Rooftop Bar gave little to no thought regarding Miss Marks getting into a car after drinking. We, the plaintiff, needed to prove that Sonny's Rooftop Bar's selling of alcohol was a substantial factor in Miss Marks' death. This was proven not only by Miss Levin telling you about how much Miss Marks was served, and by a video of Miss Marks acting drunk, and a receipt, but also from an official autopsy report. That report reveals that Miss Marks's blood alcohol content at the time of her death was 0.16. That is double the legal limit for someone 21 and 16 times the limit for a 19-year-old minor. It simply isn't reasonable to believe that Miss Marks displayed absolutely no signs of obvious intoxication. The evidence shows the only reasonable answer is that Miss Mehta saw signs and ignored them, choosing to let Miss Marks get behind the wheel of her car, drive off, endangering herself and everyone on the road. The plaintiff has met our burden. The evidence shows that Sonny's Rooftop Bar employees acted carelessly on March 24th, 2019. leading to Miss Marks's tragic death. They gave little to no thought and created permanent consequences. Don't allow Sonny's rooftop bar to continue to act recklessly. Find them liable. Thank you.
All right, thank you, Ms. Smith. Ms. Davenport, whenever you're ready, you may proceed with the defense's closing argument.
Yes, Your Honor. May it please the court, opposing counsel, members of the jury. You can't control what you can't see. Miss Marks's death was a tragedy. And there's nothing that I or Miss Smith could say to change that fact, and I'm not going to try to. However, the plaintiff has taken this tragedy and has tried to point fingers. Now, no parent should ever have to go through the pain that the Markses are going through right now. And while we recognize how difficult this situation is, we are here in court today to find the truth. Because we don't come to a court of law to do what's easy. We come here to do what's right. The plaintiff is suing Sonny's Rooftop Bar under the Dram Shop Act. Now, the plaintiff holds the burden of proof, meaning that they had to prove 4 things by a preponderance of the evidence. In other words, that it is more likely than not. 1, that Jessica Marks was a minor. 2, that Sonny's Rooftop Bar served Jessica alcohol. 3, that Miss Mehta knew Jessica Marks was obviously intoxicated when they served her alcohol. And 4, that her intoxication is what led to her death. Yet, the plaintiff couldn't prove that her intoxication is what led to her death because the plaintiff couldn't get around the fact that you can't control what you can't see. Today you heard from Morgan Levin, Jessica's grieving best friend, who also happened to be drinking that night. Morgan Levin told you that night they barely saw Miss Mehta, that she just took their orders and dropped them off. In fact, Morgan Levin, the plaintiff's own witness, told you that she couldn't remember a specific time when Jessica stumbled her speech around Miss Mehta. And she couldn't remember a specific time she appeared to have bloodshot eyes around her either. In fact, she told you she couldn't remember any specific times in which Jessica displayed symptoms of intoxication in front of Miss Mehta. In fact, what the plaintiff brought you was evidence that depends on one single witness, Morgan Levin. Today, when you go to deliberate, you're going to have to decide who is telling the truth. Morgan Levin, the teenage drinker, or Sonny Mehta, the certified bar owner. And Miss Levin came up here today and told you that Jessica fell down the stairs onto Miss Mehta. However, Miss Mehta came up here and told you that that never happened, that she never saw Jessica stumble. In fact, we later learned how much Miss Levin had to drink that night. She had a couple glasses of wine, she had a beer, and she had a shot. In fact, the plaintiff also brought you a receipt of the drinks from that night. But a receipt isn't proof that Jessica acted obviously intoxicated in front of Miss Mehta. Not only that, the receipt proves that Morgan Levin was so intoxicated, she couldn't even do simple addition correctly. Lastly, the recording. The plaintiff showed you a video of Jessica acting drunk. But Miss Mehta came up here and told you that she never saw Jessica acting like that. In fact, she said that if she did see her acting like that, she would have cut her off immediately. And in fact, she said she wished she had seen Jessica acting like that, so she could have prevented this tragedy from happening. Now, that's what the plaintiff brought you today. But I can also tell you what the plaintiff, in fact, didn't bring. Now, Miss Smith didn't bring you testimony of Miss Marks saying she was drunk. Miss Smith didn't bring you photos of Miss Marks with Miss Mehta acting intoxicated. And Miss Smith didn't even bring you an expert to tell you how the alcohol could have affected Miss Marks that night. It's almost as if they brought little to no thought as to what evidence the members of the jury would actually need. Now, today, you also heard from Miss Mehta. You heard her say that she didn't really interact with Jessica. That when she did, she seemed perfectly fine. If not, she would have cut her off. Miss Mehta didn't fail to care. She didn't fail to put in little to no thought. She told you she loves interacting with her customers. She goes through courses to make sure she knows how to identify the signs of intoxication. She checks on her customers to make sure they don't display any of those symptoms of obvious intoxication. But Miss Marks was watching out for her customers that night to make sure they were safe. But if Jessica Marks never acted obviously intoxicated in front of Miss Mehta, members of the jury, ask yourselves, how could she have possibly known she was obviously intoxicated? Now, Miss Smith didn't come up here and bring you proof that Miss Mehta knew. She only brought you Miss Levin, telling you she had to have known. She seemed drunk. I was also drunk. But she didn't tell you that Miss Mehta knew for a fact. Now, Miss Mehta is a certified bar owner who told you she goes through obvious intoxication courses every 3 years. She came up here and she told you every person handles their alcohol differently because everyone has a different metabolism. She told you she never saw Jessica slurring her words. She never saw Jessica fall down the stairs onto her. She never saw her stumble around. She never saw her acting loudly. She never saw her not making sense. She never saw any of that. Members of the jury, you can't control what you can't see. Find the defendant not liable. Thank you.
All right, thank you, Ms. Devonport. Any rebuttal from plaintiff?
Yes, Your Honor.
All right, do we know how much time is left for the rebuttal?
There's 2 minutes left.
All right, thank you. You may proceed with the rebuttal when you're ready.
Yes, Your Honor. Now, the defense just came up here and they tried to tell you that you can't control what you can't see. Members of the jury, take a look at what Sonny's rooftop bar could see, what they could control, and what they chose to ignore. Today, we have shown you evidence of how Sonny's rooftop bar viewed Jessica Marks, how they gave her little to no thought. And today's case is all about trying to be reasonable. When looking at the evidence, you have to ask yourself whether or not it is likely that Sonny's rooftop bar is at fault. Remember the fact that Jessica Marks' blood alcohol content at the time of her death was 16 times the amount of what is legal for someone her age. Now ask yourself, is it really reasonable to believe that she would have displayed no symptoms at all? No symptoms after drinking 8 different drinks in the span of 2.5 hours. Is that reasonable? No. We showed you a video from the night of March 24th, a video of Miss Marks at Sonny's rooftop bar at 11 p.m. A video where she's talking about being on Hollywood. A video where she puts sunglasses on inside. A video where she doesn't make sense. She's slurring her speech. She's showing signs of intoxication. Miss Mehta came to her table time after time. It's reasonable to believe she would have seen these signs, but she kept serving. because she gave Miss Marks little to no thought. It was that lack of thought that led to the heartbreaking death of Jessica Marks. Find Sonny's rooftop bar liable.
All right, thank you. Well, that concludes the trial. I'll ask at this time for our judges to complete their ballots and click submit and wait for our bailiff to confirm that everybody has done it right and no technical issues. And then we'll come back with some brief comments. So